All right, Steve, I believe we're ready to go.
Great. Well, let me begin with with our conflict admonition. Members of the subcommittee are advised of their duty under the State Government Ethics Act to avoid conflicts of interest and appearance of conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or appearance of conflict. Is there anyone that needs to identify a conflict before we begin? Okay, should any develop, let us know. I want to welcome everyone. I don't think, Brian, we have any new members, do we?
No, we do not.
Guard?
No, we are composed the same as we were last year.
Okay, good. So we're all acquainted with one another, and welcome everyone to 2021. Hope things get better. But we have one bit of business before we dig into today's new business, and that is the approval of the November 5, 2020 subcommittee meeting minutes. Is there a motion to that effect?
So moved.
Second.
Moved and seconded. All in favor?
Aye.
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 Opposed? The meeting minutes are approved. We're going to get started today, as indicated from the last meeting minutes. This subcommittee was tasked with broadening its scope to consider not only the rule, but the possibility of dealing with the preamble to the rules. And to that effect, in discussions with leadership and with the staff, we thought that it may be prudent and the best course of action at this time to consider the preamble. And so that's kind of the direction that we want to take this meeting. Brian's going to begin with an update of the Greenberg v. Hagerty case from Pennsylvania, where a preliminary injunction issued and was upheld on further hearing. I think it's at the circuit now. I would just note the academic pedigree of the judge in that case is pretty impressive. He's a Villanova undergrad and Temple Law, so your chairman fits that bill. So I'm endorsing the judge's academic pedigree, whatever I think of his decision. So if you want to get into that, Brian, and then we can talk a little bit about the preamble.
Sure, absolutely. So you have in your materials a copy of the decision, the order, as well as the memorandum in support of the order in this Greenberg v. Hagerty case out of the Eastern District of Pennsylvania. This case, as Steve mentioned, I'm sure a lot of you have heard about by now. This actually occurred after our last meeting in November. But essentially the district court up in Pennsylvania, up in Philadelphia, ended up taking a look at the Pennsylvania version of Rule 8.4G. It was the version that they adopted last summer that adds anti-discrimination language to their rules of professional conduct. And ultimately, the judge determined that this rule was unconstitutional, that it violated an attorney's First Amendment rights. The focus of the opinion is on the language in that Pennsylvania rule that says, essentially says, by words or conduct, a lawyer should not discriminate. And they are focusing on the inclusion of by words and saying that the prohibition of using certain words that could manifest some type of bias or discriminatory impact was unconstitutional. This came down, like I said, in December, and the Pennsylvania State Bar has appealed this to the Third Circuit. So this is now before the Third Circuit. I checked Pacer the other day, and it looks like the bar has requested an extension of time to file its brief. So the first brief isn't due until mid-March, at which point, you can expect kind of the timeline to go from there. So we probably won't have completed briefs on the issue for a couple of months. And of course, when oral argument will be scheduled, who knows? But nevertheless, just wanted to make you all aware of this decision so you can read through the opinion. We're not going to spend a lot of time on it today, but just wanted you all to be aware of it, have the opportunity to read through the opinion yourself, because I think some of the things we've talked about to this point are really quite relevant in the judge's discussion, perhaps as you look through this judge's constitutional analysis and try to think about, well, the different components of the rule. I know Carmen previously broke this down as far as, which components do we want to have in a rule, and what capacity, what type of conduct, and things of that nature. So I think it's, again, just an update. We will keep you all updated as this case develops. Before I move on to the Dispute Resolution Commission, I'll be happy to answer any other questions. All right, seeing none. I also wanted to let you know that in in December, the Dispute Resolution Commission passed its own rule, an anti-discrimination rule for their standards. You can see that in your materials as well. It's bookmarked under 3B, and it's you can see it's a rather short standard that they adopted. It's one of those things you kind of look at this, and I've talked with Tara Kozlowski at the Dispute Resolution Commission and about this particular effort. They, from what she was telling me, they, being the DRC, were kind of motivated to some extent, or at least interested in the fact that the state bar was looking at this. And so they decided to take a look at it themselves, and they ultimately approved this particular new standard that, again, focuses on while employed or engaged in a professional capacity, a mediator shall not engage in any unlawful discrimination. Of course, it puts a known or reasonably should know sort of mindset on the mediator's conduct. So again, this is kind of for your information. The status of this standard is that it is still pending. It has not been submitted to the Supreme Court just yet, but it's my understanding that they anticipate submitting it to the Supreme Court for its review sometime perhaps next month or April. I believe in light of the Pennsylvania case, they wanted to bring this back to the commission to ask the commission, do you all have any sort of inclination to amend this standard or do anything different in light of that Pennsylvania case? So they're planning to talk about that at their next meeting, which I think comes up in a couple of weeks. And then they'll just move on from there. But again, wanted you all to be aware of this, that this was actually approved by the DRC in December. And again, I'll be happy to answer any questions about that. All right, that concludes my update.
Brian, one question, if I could, about that. Who, if you know, what body would be tasked with enforcing DRC rules?
Well, it's the staff really there, and that's where Tara Kozlowski, the executive director, I understand she has a team that would be the folks that potentially investigate and enforce these standards. I don't know, frankly. I'm just not sure if it's how large of a team that is, and really what they'd be able to do in terms of enforcement or their procedures. I'm just not as familiar with the DRC. I don't know if anybody else on the subcommittee is a bit more familiar with their enforcement procedures.
Well, I can just say that they do refer things to the Office of Counsel with some regularity when they learn that a mediator, say, has made a false statement on a recertification application, things like that. They'll refer that conduct to us. So they, I think they have several people who do similar work to what our Office of Counsel does.
Are there mediators who would not be attorneys that then couldn't be referred to the bar, would be outside our jurisdiction?
Yeah, I believe there could be. I think one of the other things, though, is that the things that were previously referred to us, typically implicate a rule of professional conduct like dishonesty, and this would be an interesting one. If this is passed and we don't have a rule in place yet, that they may refer something, just kind of presuming, if they had a case that they wanted to prosecute under this standard, they would really have to tackle it themselves if we don't have a corresponding rule. All right. Well, seeing no other questions, Steve, I'll be happy to move on to the next parts of our agenda. If you want to get into the discussion on the preamble.
Yes, let's.
All right. So, like Steve said, we wanted to talk about the preamble today. That's one of the charges that the Ethics Committee sent to this subcommittee. Just kind of as a refresher, I want to make sure that we're all remembering the same thing. I want to share my screen here, so we're all looking at the same language. This was the published version of the preamble amendment after the July 2020 meeting. You all will probably recall that the Ethics Committee met in June of 2020 to talk about the different initiatives that were started, talking about this particular subcommittee as well as the other subcommittee that's studying the potential inclusion of a comment to Rule 1.1 regarding implicit bias. And then, of course, there was the preamble proposal that largely mirrored the preamble amendment that was approved by the State Bar Council back in 2010. So it was slightly tweaked, but it was, again, largely following the same format. And this was approved for publication by the State Bar Council at the July 2020 meeting. We received a lot of comments. Those comments, of course, have been disseminated to the Ethics Committee as well as this subcommittee, and they are in your materials. But we received a lot of comments before publication and after publication, which resulted in this thing being sent over, this preamble issues being sent over to this subcommittee. So where we are procedurally, we are in a spot where essentially this preamble proposal has been published for comment. It's now been sent to subcommittee. It's your chance to discuss this preamble proposal in light of the comments to see if the comments really impact your decision, your recommendation. And I guess I'm kind of referring generally to the council's recommendation to publish this particular proposal. It's really in your hands to see what concerns you may have, if you want to make any amendments in light of the comments or just any other considerations. Generally speaking, if for whatever reason you looked at the version that was published in July 2020 and say, I'm still okay with it, I still think that's the correct thing to do, you could recommend to the State Bar Council that it be adopted. It does not need to be republished unless it gets amended at this stage. But again, and we've got some thoughts. I think Carmen's going to share some thoughts on the content of the comments and where there may be some amendments that may be appropriate. Just very briefly about those comments. You all saw that there's a great deal of commentary in the materials provided today. And I just, rather than go through each one of those one by one, then I just wanted to kind of give some quick summary statistics. Overall, we received over 100 comments on this particular this preamble, or maybe I should say all of these initiatives, because a lot of these comments, as you saw, really kind of merged together the preamble, a potential amendment to the rules of professional conduct, as well as the comment to 1.1. A lot of the comments, of course, focus on Model Rule 8.4G, and there's a lot of opposition to Model Rule 8.4G. I think Carmen will probably talk about that shortly. But overall, like I said, over 100 comments in total received about these initiatives. 61 comments were offered in support. 41 were in opposition. Now, I have to say that there were a number of duplicates that were out there. So kind of those numbers are really taking into account all the different duplicates that we saw there, because you saw we may have received 3 different letters from a particular individual. We also had letters that you saw were signed by multiple lawyers. There was a letter that was signed by multiple state senators. There was another letter, and that was in opposition to any sort of amendment, particularly to any amendment, including Model Rule 8.4G. There's another letter that was signed in opposition to these initiatives, signed by, I believe it was 71 lawyers. But we received additional comments even after the October 2020 ethics meeting, when this was sent to subcommittee. We received 2 additional comments in opposition to the proposal, and 1 additional comment that was in favor of the proposal, and that was the letter that you see in your materials from the North Carolina Association of Women Attorneys. That letter is signed by 73 different attorneys. So you have a lot of support for these initiatives. There's a lot of opposition against it, and so I think at this point I would turn it over to Carmen. I think Carmen's going to share some thoughts on the content of these comments, as well as how they interact with some of the things that we've previously gone over in this subcommittee.
Yes, and I'm feeling a little under the weather, so I promise be brief. Brian said that a lot of people merged their feedback. I would use the word conflate. I think that a lot of the commentary we got wasn't applicable to the thing that is on the table. But I will, for future reference purposes, just give you some of the highlights of the constitutional criticisms that were contained in this feedback, and they were all things that we generally expected and anticipated based on what we've talked about before. In terms of free speech criticisms, there were several different vagueness arguments. The most frequently criticized phrase was the phrase related to the practice of law or acting in a professional capacity. So that is probably something we are going to want to look at when we get back to the rule. That is one of the arguments that our state legislatures made in their letter. There were other questions about, defining harassment and discrimination. There were a number of people who said that a rule like 8.4G constitutes viewpoint discrimination, creates a quote unquote thought crime, that any ban on a verbal conduct manifesting prejudice is a prohibition of speech based on its content. And some went so far as to say that such a rule is designed to allow vindictive prosecution of lawyers whose social and political beliefs do not comport with the state bar's view. I have to assume that whoever wrote that has never been to a state bar meeting, because to refer to the agency as a monolith with one view is clearly not accurate. So the two things that our legislators brought up was the question of whether this is a content-based restriction on speech, and the vagueness of related to the practice of law as a phrase. There were also some arguments based on freedom of religion. The very concise summary offered by one letter said this rule would force many of us to choose between obeying God and obeying the bar. I think when we return to our study of the rule, I would probably suggest that we get someone to explain to us how that would happen, because there is no specific example cited in that letter. Now, and then there were other broader constitutional questions. What is the compelling government interest that justifies a speech regulation, et cetera? But we don't need to talk about those arguments today, because the preamble is not a regulation. It is not a restriction on any freedoms, including any First Amendment freedoms. It's not enforceable. It doesn't come into the kind of analysis that would apply to a rule of professional conduct. And when I was trying to figure out the best analogy for what the preamble is, I thought, it's basically like a mission statement. I liken it to that. So I'm going to show you what a mission statement of a federal agency that I found that I just thought was, first of all, it's like one of the most non-controversial and boring federal agencies you can imagine. It's part of the NSA. It's basically the cybersecurity section of the NSA. And within their mission statement, oops, they have this piece, respect for people, and that, that includes their commitment to including and valuing their employees for their diverse backgrounds and experiences. So even an agency like this is acknowledging publicly in their mission statement, this is a value we have that matters to us. So I would consider the preamble very much like this kind of a mission statement. So given that, I want to tell you just what some of the criticisms were that were actually about the preamble, that were actually applicable to what this committee is looking at right now. One person suggested that passing this preamble or adopting this preamble is just a way to open the door for subsequently enacting what would be an unconstitutional rule. There were a number of criticisms that I grouped into a category that I called culture wars. But things like the suggestion that this preamble, it constitutes, quote, virtue signaling on political and social narratives of the moment. Comments like the state bar should not take a side on controversial political issues, or, quote, attempt to force attorneys to accept policies that promote controversial lifestyle and behavior choices. Similarly, we had some feedback saying that, aspirational language is in essence designed to shift societal norms, and that including sexual orientation and gender identity as characteristics that should not be the basis of discrimination. The state bar is in effect denying that people can disagree about those issues in good faith, and is in effect implying that lawyers who don't hold those beliefs are unethical, or the beliefs that are endorsed. So those criticisms are actually targeted at the preamble. Finally, there were some specific drafting criticisms that we think, Brian and I think, actually have some merit that we should look at. Let me go back to the published version of the preamble. One person pointed out that, I think because people are still somewhat uncomfortable just typing out the word sex when they're drafting a rule, that where it says gender here right after race, it should just say sex. We say gender identity later on in the list, and biological sex and gender identity are the two things that are being distinguished here as two different issues. So that is just a typo almost. And then also, there was a criticism of the last sentence, the sentence that says that the responsibility of non-discrimination doesn't limit a lawyer's right to advocate, accept, decline, or withdraw from representation in accordance with the rules. Now, some of the feedback said that language, which is also in Model Rule 8.4G, really undercuts itself because it makes reference to other rules, and other rules could be changed, and therefore it's really no safe harbor at all. And I think that's something that is worth considering and talking about when we return to the rule. And Brian and I talked about maybe merely just striking in accordance with these rules. That's really not, it's sort of superfluous. But then we started talking more about how in a statement of aspiration, like the preamble, that entire sentence really isn't necessary, because we're not stating a responsibility. We're stating what we hope for from our profession. And Brian had already started thinking about ways, language that we could add into potential language here to just reframe the preamble. And then we decided, well, what would it look like if we added some of the language that Brian had come up with and turned it around so it was phrased in the same way as all the other paragraphs in the preamble. And by that, I mean, it would state, it would be phrased in the affirmative rather than as a prohibition. So, you know, here we say a lawyer should not, but all the other paragraphs say what a lawyer should do. So I'm just gonna show you this sort of totally just an example of what that might look like that Brian and I talked about earlier this week. And then I will turn it back over to Brian unless you have any questions about the criticisms that I just talked about.
All right, thanks, Carmen. And yeah, I guess I want to, before we get into actual discussion of any of these proposals, I just want to make sure, see if anybody has any questions about or concerns about, you know, anything we've talked about before, constitutional issues that are applicable to the preamble or not applicable due to the aspirational nature of the provision, things of that nature. So just want to offer that opportunity to everybody.
I do have a question.
Oh, sorry. Let me know, Brian, if you want me to put that back up at any time.
Okay. Thanks,
I do have a question about when you were talking about that word, the words, gender identity. Can you go back? Because I wasn't catching what you were saying.
Sure. So the way it was phrased in the published version was that a lawyer shall not discriminate on the basis of race, sex,
here, I'll share it, Carmen,
et cetera, gender identity. I'm sorry, it said race, gender, and then later in the list, it said gender identity.
Okay.
And what I was saying is that what we really meant there was race, sex, national orientation, religion, age, disability. Because gender is, you know, a social construct, whereas sex is just the parts we are given at birth. So that is.
Okay, so I was seeing it I was reading it to be exactly what you said. I'm reading gender is what you were born with. I'm using those words interchangeably, and then gender identity is what you actually identify with.
Right.
Okay.
And but I think technically it's.
I got you.
Yeah.
All right.
All right, anybody else have any other questions about kind of constitutional concerns or anything else about just the nature of an aspirational provision in the preamble?
If I might, go ahead, Colin.
Oh, you're on mute, Colin.
Sorry. Carmen, you mentioned early that one of the issues that about the preamble was the phrase about in a professional capacity. And I just, is there anything that we should look at about that phrase? I mean, it seemed like we were trying to separate your personal life and what you thought and believed and said from your professional life. Our job is to regulate your professional life. But I mean, is there any way for us to should we look at that as that phrase and look at alternatives?
I think in the context of the preamble, I'm less concerned about whether that phrase is a little bit vague, but what we might want to do is just comb the rest of the preamble and see if there's any way in which that is already captured. You know, if there is another paragraph that talks about what lawyers should do essentially in their professional life or in connection with their practice, and then we could just mirror that language if we decided to make that change. But again, I think the question of whether it's adequately defined is one that we're just going to have to take up with much more vigor when we get to talking about a rule.
I think, Colin, if you look at their alternative for the preamble, they don't have that. It's framed in a different way. Personally, I love the thought of thinking of it as kind of the mission statement or the framework that we need to get right before we go on to, you know, discussing a rule or anything else.
Right. I mean, some of the things in the preamble talk about, you know, in professional functions or just a lawyer's conduct, and it doesn't. I didn't see that phrase, but I didn't know if there was. I mean, it seemed like to me that was a very limiting phrase. So that made it a very limited rule, that we're not trying to get in people's personal life. We're just looking at how your conduct as a lawyer.
Right, right. And perhaps, as one example, this alternative we have up there, I think treating all persons we encounter in our professional capacity, that seems fairly limited, perhaps. So,
yeah. I guess there was another alternative that said treating all persons involved in the legal process.
Yes. So
yes.
the one that, so just kind of I guess make sense of all the different alternatives out there. There's one in the materials that I had drafted kind of based upon the prior charge that Carmen and I received to try to draft a rule, see what we could come up with. And I kind of massaged that for this meeting. But then earlier this week, Carmen and I were discussing this, I guess this example that's on your screen right here, and really trying to make sure that we are matching as she described, the affirmative duty that we see in the preamble. And that is, just looking through.
Not a duty, just a recommendation.
That's true. That's my fault. Mixing or using the incorrect word. Just that it is this aspirational goal that we have, and not framing it in a you should not do something, but you should do this. And so Carmen and I went through and kind of, I guess, adjusted that alternative even further to what you see here. I think, Barbara, you point out this the question of professional capacity versus involved in the legal process. And I think that's probably open for debate on which one is more applicable. The professional capacity, I think some of the criticism that we received from some of the comments was that professional capacity could be anything from representation to attending a social event for a local bar, whereas the legal process is probably a little bit more specific to some type of, whether it's representation or just involvement in the pursuit of justice. But we're getting
right.
into kind of a semantics thing and how people subjectively interpret those terms. So
right, but then again, you have to think it's not so much of a stretch to suggest that even at local bar social events,
right.
lawyers should treat each other courteously, respectfully, and with dignity.
Right.
Like, that's not going very far.
No.
Right.
Not when it's all tied together like this. Yeah, no, I agree.
See, Dorothy has her hand up.
Sorry, I was trying to get to my mute button. Where do I start? So one of the letters that includes like a lot of attorneys that's attached to it has this position that, one, the changes to the preamble with some kind of way, I think they specifically say implying that attorneys who disagree are unethical. So I first want to hear from you all your thoughts on that, because I don't get anywhere in any of what the preamble nor the rule where it comes off as if we're saying you like minds can't folks can't disagree. And so I also wonder, like, it seems like a lot of these letters and emails and things comes as if we are trying to regulate people's thoughts. And that's really not what the regulation is about, or at least that's not what I thought. I thought it was, you can think whatever you want to think, but it's when you actually take some action on discriminatory thoughts and you take some kind of discriminatory action as a lawyer, that's when it becomes a problem. And so that's first off. And then it talks about that the bar is taking the position, us as the state bar, we're taking a position on sexual orientation, gender identity, and other active political issues just by simply stating that you shouldn't discriminate on any of these bases. So is that, you know, kind of the same notion that you got, Carmen, when you were going through these? Like, I'm trying to reconcile, like, I don't want to say I
Yes.
don't understand it, because I just don't, because I just disagree
Yes.
with it. That's why I don't understand it. But it seems like, I mean, it's a really far stretch, because I don't see how folks are reading what we're proposing as we're trying to regulate what somebody is just thinking.
Right. Well, to your point, I agree with you. It's not that I don't understand it, it's that I don't agree with it. And let me give you an example. The preamble also very strongly encourages lawyers to engage in pro bono service, right? It doesn't imply that lawyers who don't do that are unethical. It also is not, that's not an endorsement of communism, right? I mean, giving stuff away. I mean, that's ridiculous, right? I mean, that's not, I think it's one of those positions that is hyperbolic at best. So I agree with you. I don't think that's a risk here.
That's a great example that you just gave as far as the other. So that leads me to my other question. And I'm not suggesting this, but have we put any thought into providing some examples, like what we've seen in some other rules where we say these are the types of examples of, or these are the types of behavior that would be considered discriminatory? Because when I've read most of these emails and these letters, it's as if folks have the folks that are in opposition have no clue what discriminatory behavior is, when I know they do. You know what I mean? Or is it that you're the ones that's discriminating and you see what you're doing is normal? I mean,
I think just to that end, Dorothy, I feel like those types of examples would probably be more appropriate when we get to the stage of discussing a rule, and maybe including in the comments.
Well, that's what I was talking about as
Okay.
relates to, and I'm not necessarily an advocate for those, because I think we're going to get into some murky water when we start trying to give examples. I'm just, you know, simply throwing it out there that this, when I was reading, I'm like, clearly they know what we're talking about. Like
I think, Dorothy, sadly, you know, we're just in a time of a lot of distrust. And so people look at this and they're reading into it and saying somebody, you know, what some of them are thinking is someone that thinks different than me wants to get this in here, and then they're going to use it against me, you know, find some way. There's just a lot of distrust and a lot of division. And that's why, you know, I'm just hoping we could at least start with kind of a framework, find what it's, you know, well, we should all be able to agree what we aspire to do. That the fear comes in the discipline.
Right. I definitely now see why, when we were having these discussions, what it seems like years ago, why folks were pushing the preamble and not pushing the preamble and the rule together, because we clearly would have, you know, been further along if we, and I was one of those that was kind of against it. It's like, you know, I would love to have the preamble with the rule in addition to the preamble, but if I have to split the baby in some way, I mean, clearly we want the aspirational language in there.
Or maybe just say it's a start. Let's start with what we can start with.
Because like I said before, like I know folks who, especially the groups that are typically the groups that are discriminated against, you want to have some meat to it. You want to have some action behind, you know, we want everybody to encourage people to aspire to be these things, but we want something to be able to happen too if they don't. But at the same time, you know, so now this is bringing it back around full circle, basically, and making me remember why we, you know, started and now are still where we're at.
You know, there are always going to be people, a handful of people who are resistant to change. And I think that, as I mentioned in our first couple of meetings, that what we need to do is get it as right as we think we can, that would survive the challenge and stay on that path of doing something proactive and progressive and doing the right thing. Like I said, there are going to always be people in the profession who are going to disagree, whether it's because they're just resistant to change or just because they have their own personal views about racial issues and other issues that they're not going to budge on. I think this committee is doing the right thing. I think we're heading in the right direction, and I think despite comments that are opposed to this. I think we stay on this path, and we do what we believe is right and appropriate. And as long as we are comfortable that it could withstand legal challenge, we stay right on that path.
I totally agree.
You know, Brian, just specifically, I mean, just my opinion, I don't know about the committees. I would rather move away from what was originally published, because I do think looking at it in the context of the whole preamble, it fits better to kind of go the new direction, saying, this is what you should do. This fosters public trust and confidence. This is important, you know, to the system of justice. That kind of fits with everything else.
Yeah, and I think it does invite conflating the preamble and the rule when the language is so similar.
I do too.
So,
Yeah, over and over again, the preamble talks about what you should do. And I think we need to stay away from thou shalt nots in the preamble as much as we can.
I totally agree.
Well, at this point, I guess I want to make sure that we're giving everybody an opportunity to voice their opinion. Does anybody have, I guess maybe we're kind of trying to kind of sort out where exactly are we? I guess I get the sense that we do still feel comfortable and interested in having some amendment to the preamble.
Yes.
But I don't know if there's anybody who feels differently here, that an amendment to the preamble is not needed. And I want to be sure that people get the opportunity to talk if they have a different point of view. But moving, I guess, from that question, an additional question is, if we do want to proceed, what exactly do we want to have, or what do we want to recommend? Do we want to go to a drafting process or something like that? So just, again, the floor is open for this type of conversation, especially if anybody feels differently that a preamble amendment is unnecessary.
I don't want to put you on the spot, John Webster, but you're one of our fellows who is practicing in a in a more rural area of the country, and I know you have your pulse on the sense of the bar down there, and wonder what thoughts you might have as to whether or not we should proceed even with this kind of language in the preamble.
Well, I actually am agreeing a lot with the comments that I'm hearing, but I may be different than a lot of the people that live here. I don't get a lot of response from fellow bar members here unless it's a specific individual complaint about something that they're dealing with. So there's really not a whole lot of discussion here as far as from the lawyers. And I'll be honest, I don't know that people in my neck of the woods really pay much attention to what's going on at the state bar. They just, unless there's a problem, like I say, it's more of a reactionary thing. So I don't really have a problem with what's been proposed personally. That's why I haven't really been commenting, because I think it's all good work. So to that end, I don't know, Steve, like if I'll be glad to force this along to some folks here and see what they say. But I don't know that the lawyers would necessarily disagree with what we're doing, the direction we're going. General public, I don't know that you're going to get a whole lot of feedback from folks. I just think they're disinterested until there's an issue that comes up that might affect them. And this isn't going to be one of those issues, I don't think.
Well, I thanks for those thoughts, John. I think that's one of the benefits of proceeding with the preamble, is that we don't bring the full force and weight of the bar down on our colleagues all at once, maybe by having this more aspirational language that we sort of ease into it in a more collegial manner. Brian, what we're looking at today is a completely new draft, right? It's not the one from the preamble alternative that's included in our materials, but it's close.
It is, and that's where I think the slide that Carmen shared is kind of one version, I think, and of course you have the version that I've included in the materials. But frankly, I like the version that Carmen shared. I think it is more direct. It's not as wordy. And so I think, I was just about to ask Carmen if you wouldn't mind putting that on the screen. So looking at this version, like I said, this is kind of based off of the draft that I had put together back in November, and it's focusing on trying to, I guess, fit in with the overall structure of the other preamble provisions, but really focusing on I think what is the underlying issue here when we're talking about anti-discrimination language. It's that, and even citing what our new Chief Justice always points out, the North Carolina Constitution requires that right and justice shall be administered without favor, denial, or delay. And particularly that without favor and without denial, I think is what we're talking about here when we're talking about anti-discrimination language, that really we are fostering public confidence in the justice system by aspiring to treat everyone equally, fairly, honestly, and respectfully within the system. And so that's exactly what this proposal states. It goes on to say, of course, as you see, a lawyer as a representative of and crucial contributor to the justice system should foster public confidence in the administration of justice by treating all persons they encounter in their professional capacity equally, courteously, so respectfully, and with dignity, regardless of the person's race, sex, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. And that's just and that's where we end there. We've eliminated that last part because, as Carmen said, it's really not necessary because we're talking about our aspirational goal that, again, just to treat everybody respectfully and courteously without regard to any of those identifying characteristics. So I think this would be my recommendation for whatever that's worth. I think, Carmen, I believe, I don't want to speak for you, but I think this would be your recommendation too, at least I put it this way, at the very least to have as our new starting point if we decide to move in a direction, not just to amend the preamble, but to kind of change the tone of the proposed preamble amendment.
Yeah, I think it's a good starting point. I concur.
I'm at least of the opinion that it's a pretty good final product.
I'm with you, Mac. I think it's I'm unless I'm missing something, it really does look good.
I agree.
Given that this is a subcommittee of ethics, I realize that it's tradition that we beat this horse to death, but if there's no need to do that, this looks pretty good.
Well, maybe we can, I'll bring in some additional speakers to all say what they think, Mac, just for you, if that's all right. Okay.
Please, more the merrier.
Everything's been said, but everybody hadn't said it yet.
Well, as Brian said at the outset, the place we are in the process is that if we are going to redraft, which it seems like there's some consensus for that what we would have to do is republish. So we would essentially withdraw what we've done, given that we've had how many comments? Over 100 comments. It probably needed some redraft. Is there any, so anyway, that's where we are in the process. So I just want to make sure all the committee members understand that, and the leadership folks that are on the call. Barbara, I don't know if you feel it's appropriate for our committee to take a vote at this point, or we should, or what we should do in terms of republishing. I'd be interested in your thinking on that.
I don't know. I mean, Brian, you or Alice may be on there. I don't know if it could go straight from here to publication. I mean, it'd have to go.
No, you're right.
It'd be the council, right? That would have
Yes.
to
Go to the ethics committee first, shouldn't it?
Yeah, so procedurally speaking, what we would see is if this subcommittee agrees that this version would be the subcommittee's recommendation to withdraw the previously proposed preamble amendment and instead substitute it with this version, there'd be a recommendation. I think we need a motion from the subcommittee to recommend publication of this version that you see on your screen. at which point it would go to the Ethics Committee for its consideration, and then to the State Park Council for publication at the April 2021 meeting.
I would make the motion.
Second.
All in favor?
Aye.
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 I believe that's unanimous. Opposed? None opposed? I think then that would be our recommendation to the Ethics Committee, Brian.
All right. Well, then we will, I think that concludes our work here for today. What we will do is, prepare this for transmission to the council. And like I said, it's going to go before the Ethics Committee. So Steve, you'll provide a report at the Ethics Committee about the subcommittee's discussion. Everybody on this call, whether you're on grievance or ethics, please feel free to attend the ethics meeting. I think the way that we structured these things, you could attend at least a portion of this. This, Mac, just so you know, this would be at the beginning of the meeting, so you could skip out for the rest. But nevertheless, we'll have this thing ready to go and present it at the April 2021 meeting.
Is David Allen, is the chairman on this call today?
No, David is not here today.
Should somebody reach out to him and kind of let him know what's going on?
I'm planning to do that, yes.
See the new sign that's up?
Yeah, so we'll do that. And I think the only other thing then that we would need to consider is the next steps if we want to meet for an additional meeting this quarter or anything like that. But Steve, perhaps you and I can talk outside of this particular call and figure that out.
Okay, great. Thank you all very much.
Thank you.
Thanks, Sam.
Have a good day.
Thanks.